Scott Horton with Horton Law, my own law firm. I practice labor and employment law with an office in Orchard Park, New York, but I do practice throughout the state, advising employers exclusively on labor and employment law matters. This New York paid family leave law is certainly a critical topic in that area, and one that I've had a chance to write quite a bit about, that I post on my blog through my website. And I just wanted to have the opportunity to share more information with all of you through this webinar. So this is definitely a complicated problem for a lot of employers in New York State. A lot of smaller employers who never had to worry about paid family or family leave laws before, the FMLA applying only to employers with 50 or more employees. And even for employers of that size, of course, this is new because it's now a paid leave law. So there is a lot out there statutorily, by regulation, and guidance from the New York State Workers' Compensation Board, which for most practical purposes administers this law. And I just want to try to shed some light on some of the most important components of this. As I mentioned before, I think we'll last about an hour here, and then I will stay on as long as necessary to answer any questions that you have. Of course, I do need to make a disclaimer up front that while I am an attorney and I am talking about the law and some of its implications, and while most likely some of you are my clients, I'm not giving legal advice per se, because I am not talking about your specific circumstances. This is informational of a general nature. If you do have any questions that you want to ask later on, that is great, but it will not be in a privileged attorney-client communication. So keep that in mind. If we need to have that conversation separately, we can, of course, do so. Okay, so why are we here? Because there is a lot of information, and it's quite a lot to try to take in, and I've been doing it myself, and I'm sure many of you have been trying to get as much information as you can, knowing this is coming starting January 1st of 2018. So right now there's a lot of input coming in, and what I'm hoping we can do is put a nice framework on it, so at least you have the basics organized, in your mind as you go forward toward the launch of 2018, and you'll be more relaxed and at ease with the program. Not to say that it's going to necessarily be an easy or fun one for many of you to have to deal with, but it'll be there with this knowledge base from this webinar. And like I mentioned earlier, I will try to have another webinar at the right time in the next couple of months, and I will send all of you an email announcing that, to get into some new emerging questions about paid family leave in New York, and to let you know of any updates. So let me first tell you what we're going to discuss today. I've broken it down into 6 main topics, being coverage of the law, payroll deductions, the leave that's allowed, and the qualifying circumstances, what benefits are available to employees, the notice requirements, and other administrative issues. To go into that a little more specifically, we're going to talk about what employers are covered, what employees are eligible to take paid family leave. We'll then discuss briefly the payroll deductions. Some of you have already been dealing with this because the law did allow employers to start making deductions from their employee pay to pay for paid family leave beginning July 1 of 2017. So some of you may have already dealt with some of those issues, but I want to talk about that, of course. The leave issues, we'll go over the qualifying circumstances, and we'll also talk about how much leave is available and some of the parameters on that. Then we'll do a little bit on the leave benefits. In other words, because it is a paid family leave law, of course, it's not just the fact that the employees can take the leave, but also that they're going to get paid. So we need to go into some detail on that component of the law. Now, the notice requirements, we'll talk about both the employer and employee requirements, and that'll kind of lead us into the administrative issues, the claim processing, and dispute resolution procedures of the law. For the most part, that's the overview of what we're discussing today, obviously with more details on each of these topics. Okay, so we're going to move to coverage issues. If you are in the private sector, non-governmental employers, for the most part, you're going to be subject to the paid family leave law. If you've had one employee in New York State for at least 10 weeks, then you're covered by the law. Another way of saying it is if you are covered by the disability benefits requirements of New York State law, then for most purposes, you are going to be subject to the New York State paid family leave law. For private employers, there are a couple of peculiar exceptions. If, for example, you are a railroad or maritime operation, have farm laborers, golf caddies, black car operators, jockeys, then you wouldn't be subject to the paid family leave law with respect to those employees. I don't think that covers anyone in here. There's also some exception for Native American owned corporations. And if that applies to you, you've probably already been looking at those issues. So for most of you, this is all going to apply. For public employers, the one question that you definitely need to ask right now is, are you currently providing short-term disability benefit per New York law? If you are, that doesn't necessarily mean that you're going to be required to have paid family leave for your employees. The default is that public employers are not covered by the paid family leave law, just as they're not covered by the existing short-term disability benefits law. But if you are a public employer who currently provides short-term disability insurance for any of your employees, then you have to give notice to all of your employees that are eligible for disability benefits by December 1st of this year, whether you are also going to provide the paid family leave coverage. So again, this is going to be something where it doesn't necessarily mean they're covered, but you have to let them know whether you're going to cover them or not. And for represented, in other words, unionized public employees, this is a subject for bargaining. So if the union demands bargaining over whether employees are going to receive paid family leave benefit, that's something that you will have to negotiate. So one of the problems is that if you currently provide disability benefits, then you have to give this notice saying that we're not going to provide paid family leave, for example, and then you risk that the employees will get together and say, hey, maybe we should have this, and seek to negotiate it. At this point, my suggestion would be most public employers aren't going to want to get involved in the paid family leave law if they can avoid it. And if they can stay out of it, then none of the rest of this is going to apply. But, you definitely should find out what it's about so you know what you don't want to have apply to you. For nonprofit institutions, you are covered, assuming you have an employee in New York for at least 10 weeks. But if you're a religious, charitable, or educational institution, then some of your employees may not automatically be eligible for the paid family leave benefits. Most employees are covered once they've worked long enough, and we'll talk about that. But for these recognized charitable institutions, which some of you probably do work for, first of all, clergy is not covered if you're a religious institution, for example. Executive officers are also not automatically covered. Volunteers aren't covered. They're not really employees, as long as they're not being paid and they're not otherwise going to be classified as employees. And then probably the most applicable in certain organizations, especially private schools and colleges, for example, employees employed in professional or teaching capacities are not automatically covered by the paid benefit, paid family leave benefits. So what that means is you may have a decision to make if you qualify for one of these situations, whether you want to extend paid family leave benefits to those excluded employees in addition to all of your other employees. If you currently provide disability benefits, short-term disability benefits for them under your group policy that covers everyone else, then practically speaking, you're probably going to extend the paid family leave to them. But if you have carved these people out from the disability benefits law, then you can also keep them carved out for paid family leave. Okay, now once we get down to employees who are eligible for paid family leave under the New York law, we have to talk about when they become eligible, because it's not automatic day one of their employment. So it's based on how many hours per week they are regularly scheduled to work. If they are regularly scheduled to work 20 or more hours in a week, then there's one test. If they are regularly scheduled to work less than 20 hours per week, then there's a different test. So essentially, this is kind of a part-time, full-time division, but one that very well may not line up with what you normally consider part-time and full-time employees within your organization. For employees who are regularly scheduled to work 20 or more hours per week, they become eligible after 26 consecutive work weeks of employment. So if you have employees now who've been employed for more than 26 weeks and they remain employed through the end of this year, they will become eligible for the paid family leave law on January 1st of 2018. Anyone you hire going forward, they won't become eligible to take paid family leave until they have worked 26 consecutive weeks. This includes vacation, personal time, sick time. So if you take a vacation, that doesn't break up the 26 consecutive weeks, but otherwise it does have to be consecutive. The regulations to the law specifically say that New York State temporary disability leave does not count. It doesn't mention workers' compensation leave. So honestly, I'm not sure right now whether that counts. But in other words, if you have somebody who within the first 26 weeks of their employment was out on disability leave, then that would interrupt their eligibility. But I should also note that this is a one-time qualifier. So the fact that someone hasn't worked for the past 26 consecutive weeks at the time they seek to take paid family leave doesn't necessarily mean they're not eligible to take leave. Once they have worked 26 consecutive weeks for you, then they would become eligible going forward throughout their employment. Now let's switch over to the part-time employees, if you want, or the people that are regularly scheduled to work less than 20 hours per week. Their eligibility is triggered by working 175 days. So again, this doesn't have to be within any certain period of time, and it doesn't matter apparently whether they work 2-hour days or 12-hour days. If on average they're regularly scheduled to work less than 20 hours per week, once they have worked for you for 175 days, then they're eligible. Interestingly, again, the approved leave seems to count here. So the days that they were authorized to take vacation or personal time and probably were paid for it, then that would also count as a day worked. Again, the New York State temporary disability leave would not count. Now we're talking about regularly scheduled hours, which I'm sure is going to be an issue, but there's no further guidance as to what that means. So I'm just using the terms that the Workers' Compensation Board has put in the regulations, but I can't really tell you this is exactly what it means. Obviously, there are going to be a lot of pretty clear cases But at the margins, if you have somebody who works 40 hours one week and 10 hours the next week, are they regularly scheduled to work 20 hours per week or not? A lot of practical situations that may not matter, because by the time they've worked 26 consecutive weeks, they would have worked 175 days anyway. But I definitely foresee there being some gray area there where we're just left somewhat uncertain what the outcome is. So those will probably have to be dealt with on a as they come basis. Couple notes then, just to compare the eligibility to the FMLA. The FMLA required that employees have been employed for a year. Obviously, the 26 consecutive weeks or 175-day requirements can be less than a year. Could be that somebody who's regularly scheduled to work less than 20 hours per week wouldn't become eligible until they've worked for more than a year, but that's not a requirement for the paid family leave in New York. The FMLA interaction is going to get complicated in some cases where both do apply, where the employees are eligible for both FMLA and paid family leave. This webinar is not going to comprehensively, tackle that interaction. As I mentioned at the beginning or just before we started, I do plan to have another webinar on the New York paid family leave where I do address some more of the interaction with the FMLA and some more of the emerging issues as we get closer to January 1st. So look for your email for an invite to that presentation. There is no hours worked requirement at the time you take leave. So under FMLA, to take leave, an employee has to have worked 1,250 or more hours in the past year. Again, that's out under the New York paid family leave. Once you work the 26 consecutive weeks or the 175 days as applicable, you are then covered throughout your employment. You don't have to meet any hour requirement to become eligible for leave. And also, where the FMLA requires that there be 50 or more employees within a 70-mile radius, on the theory that without enough employees nearby, an employer may not be able to cover for someone taking FMLA leave. And notwithstanding the fact that the New York law is going to give paid leave and probably make it even easier and more likely for employees to take the time off, New York says even if you only have one employee, if they are eligible, then they have the right to take New York paid family leave. All right, so who is paying for this? It is an insurance-based product like your New York short-term disability insurance, for those of you who have that, which is most of you. And the system is set up to be paid based on employee contributions deducted from payroll. It's a very small contribution on a weekly basis anyway. The current guideline is that an employee's wages can have up to 0.126% deducted with a cap of $1.65 per week. I think if you looked at most employees, especially that aren't at higher managerial levels, we're probably talking less than $1 per week right now from their pay, but still that could work out to around $50 per year that employees may not want deducted from their pay, may not understand why it's being deducted. Now, the other problem with the law as it's written is, while it's clearly intended to be an employee paid system and publicized that way, there's nothing stopping employers from paying for the coverage. And that might actually create problems, especially if you have unionized employees, because it's likely that it would be a subject of bargaining whether you have to pay that contribution rather than taking it from employees' pay. So if any of you are dealing with that, keep that in mind. It's not entirely clear from the regulations, but I've heard straight from the general counsel of the Workers' Compensation Board that yes, it is their position that employers can pay for this insurance coverage. They do not have to make the deductions. Now, I'm going to put up a poll because I am kind of curious about this. You were able to start making deductions back in July. So I'm going to put up a poll to see how many of you have started making deductions. If you're willing to, contribute, it's anonymous. It'd just be interesting to see how many people have started to make those contributions. So let that poll go for a minute or two. The other significant issue with the contribution of the deductions from payroll is that employees might be able to waive both the contribution and the coverage and benefits of the paid family leave law that would come along with it. So if they do waive coverage, then they're not going to be eligible for the paid family leave benefits. But in order to be able to waive it in the first place, they would have to be in a situation where they're not likely to become eligible anyway. In other words, the employee either has to have a regular schedule of 20 or more hours per week, but will never work 26 consecutive weeks, or they have to have a schedule of less than 20 hours per week and will never work 175 days in any 52 consecutive weeks. I think I may have misstated that earlier. So it's 175 days within 52 consecutive weeks. So I was comparing the FMLA. It would never be a situation where it would take somebody more than a year in the sense of their 175 days aggregating across the year. But if they don't get the 175 days within 52 consecutive weeks, then they'd have to start over. So sorry for the confusion there. But so most of you, it looks like over 80% have not started making the deductions. And that's along the lines of what I was expecting to hear. You have to deal with your insurance broker to figure out how much the premium is going to cost and what the timing of it's going to be to determine when you should start making those deductions. But I think you should also keep in mind that once you do start taking that money from employees' paychecks, they probably have a right to know that you're doing it. I say that I don't think they have a legal right actually, but you don't want to be the employer that just started taking money away. So you want to consider what notice you want to give, whether you want to have discussions with employees about that. But the other thing is the regulations as they came out in final form do seem to require employers to affirmatively give employees the option to waive their contribution and the coverage. So if you have employees who are not likely to work for 26 consecutive weeks or 175 days and 52 consecutive weeks as applicable, the way I read the regulations, you are going to need to give them a form that gives them the option to waive coverage. You can't encourage them to waive coverage, but you have to give them the form giving them the option. As far as I can tell, there's no waiver form out from the Workers' Compensation Board yet. But again, I have heard the general counsel of the Workers' Compensation Board say that there will be such a form. In the meantime, if you are taking money out of your employees' paychecks, I think you need to consider whether some of those people would have the right to waive coverage, and therefore whether you should be giving them that option before you make any further deductions from their pay to contribute to the cost of the coverage. All right, let's talk some about once you have employees who are eligible, which can start as early as January 1st of 2018, what situations may enable them to take leave. So the primary coverage issues are birth, adoption, or foster care of a child, the serious health condition of a family member, or the military deployment of a family member, and the so-called qualifying exigencies that some of you are familiar with under the FMLA that relate to military deployment. Interestingly, what's not included then, unlike the FMLA, the New York Paid Family Leave Law does not cover an employee's own serious health condition. It's only for leave related to family members. Why is that? Because in essence, the law assumes that there's already New York State paid coverage available related to an employee's own medical condition. Either you're covered by workers' compensation. You see we have this picture here where, someone at work steps on a screw or nail, goes into their foot, and they're out of work for some time. They're going to receive workers' compensation benefits. Or this other picture I found, thought contrasted kind of nicely. You have sort of the weekend warrior here who is chopping some firewood, or for example, with his chainsaw, holding the log with his bare foot, which to me didn't seem like a great idea. Certainly seemed like it could potentially go wrong and cause him to have to miss some work. Anyway, if either of these situations did result in someone missing work, they would not be able to use the paid family leave benefits for that time, but they might be covered by workers' compensation and short-term disability. There's a couple important notes about that. First of all, especially the disability benefits are much lower as far as the amount of compensation that's provided. And then to be really technical about it, it's not clear that the leave entitlement for either workers' compensation or short-term disability is as robust as it is under the paid family leave benefits law. In other words, for the paid family leave law, pretty clearly obligates employers to maintain the employee's position and reinstate them after the leave to an extent technically beyond what the workers' compensation and short-term disability leave laws require. Probably more of a technicality than it's worth because of the disability discrimination laws, the ADA and the human rights law that would kick in related to the employee's own health condition. But again, the notion that the paid family leave benefit law doesn't cover an employee's own medical conditions because that's already covered under New York law is a little bit of a fiction, but it is what it is, and we are where we are, and that will make, in particular, some interesting interactions with the FMLA. Let's first describe what a family member includes. I made this little chart that sort of goes from top to bottom along the generational spectrum, at least roughly. So at the top you have grandparents, and then parents, and then in the middle you have spouses and domestic partners. So domestic partners are covered, and then children and grandchildren. So leave for the serious health condition of any of these relatives is covered, assuming all the other conditions are met. I put an asterisk at the top and bottom between next to grandparent and grandchild because those categories are not available in connection with the military deployment related leave. So if by chance you have a grandparent who is deployed to active military duty, you won't be eligible to take New York paid family leave based on that deployment. I think it's somewhat practically unlikely that you'll have an employer with either a grandparent or grandchild employed to active military duty, but there are circumstances where it could happen, but it's not covered by the law. But if they're dealing with serious health conditions for those relatives, then leave may be available. Just briefly then, a child is a biological, adopted, or foster son or daughter, stepson, stepdaughter, legal ward, even the son or daughter of a domestic partner, or a person to whom the employee stands in loco parentis. It was clear that the Workers' Compensation Board, like the New York State legislature intended this to be as broad as possible a definition of child, while still having some indicia of, stability and certainty, and not just any, individual that you want to call your child. Now, that being said, unlike the FMLA, there's no age limit on the paid family leave definition of child. So this would include leave to care for the serious health condition of an adult child as well. Parent is just sort of the flip side definition of child. So the reciprocal there also broadly defined, albeit without the express reference to domestic partners. Domestic partner itself is defined in the workers' compensation law as a person at least 18 years of age, other than a close blood relative, who is dependent upon the employee for support, is shown by either unilateral dependence or mutual independence, as evident by various certain factors. I'm not going to try to get too far into that right now, but that is the definition for your reference. I mean, clearly you can't claim that your close blood relative is your domestic partner. And other than that, if you live with the person and you rely on each other for normal householding obligations, then that may qualify. Okay, let's go into serious health condition. I'm not going to spend too much time on the details of what is a serious health condition under this law. It's virtually identical to the serious health condition under the federal FMLA, Family and Medical Leave Act. So if you're familiar with that, it's basically the same analysis. But just to go over some of the highlights, it's either something that requires inpatient care or continuing treatment or supervision by a healthcare provider. So inpatient care tends to be pretty easy. Is the person in the hospital, in hospice, or a residential healthcare facility? And obviously this has to all be related to some sort of bodily impairment, including psychological impairments. The continuing treatment or supervision, there's a few different paths to coverage here. The person has to be unable to work, attend school, etc., for more than 3 consecutive days. If that's true, then there are additional elements that also have to be met that aren't shown here on this slide. They have to be receiving care from a physician. They have to have gone in to have seen a doctor or some kind of medical provider, various things that also applied under the FMLA. But that's one line. Another is whether the person is incapacitated due to a chronic condition, or if they're incapacitated in some way for which treatment may not be effective, even if it's not necessarily a chronic condition. In other words, we're not going to require that you have gone in and seen a doctor if it wouldn't do any good to see a doctor. And then finally, if the incapacity itself is due to treatment by the healthcare provider. So if someone who wouldn't be incapacitated by the medical condition itself is nonetheless seeking and receiving care to treat the medical condition, and that treatment itself incapacitates the person, then they may qualify as having a serious health condition under the paid family leave law. Again, the regulations are much more extensive on that, but for our purposes, that's sufficient. I think if you have specific questions, we can try to tackle them later. The last component, the military leave related qualifying circumstances, relate to the qualifying exigencies as defined under the Federal Family Medical Leave Act. So if you have any experience with the FMLA and military related leaves there, you know that there's a long list of things that qualify as qualifying exigencies. Basically, if somebody's going to be deployed in active military duty and that causes, for example, their children to need coverage or business affair to be overseen, etc., or, frankly, just the time to go see them off. Those may be circumstances that permit paid family leave in New York, as they may for eligible employees under the FMLA. So the law in New York specifically references the FMLA and the regulations issued by the U.S. Department of Labor for qualifying exigencies. So I've just put on this slide what has been specifically listed by the Department of Labor, the U.S. Department of Labor, that is. And you'll notice the last item they list is any other event that the employee and employer agree is a qualifying exigency. Which is, a reasonably practical solution, especially under the FMLA, because we don't need to get hung up on is this or is this not a qualifying exigency. We can just kind of agree, all right, well, we're gonna let this apply, and that way there's no uncertainty under the law whether the time counts as FMLA leave or not. The interesting thing, as we'll get to here, is under the New York Paid Family Leave law, the employer is actually not the entity in most cases that determines whether or not leave qualifies for paid family leave. Actually, the insurer has the carrier or a self-insured employer has that obligation. So on one hand, apparently the employee and employer can agree that something is a qualifying exigency, then I guess that's going to be binding on the insurance carrier, for example. So that's a peculiarity that I'm not sure anybody considered when they just whole cloth adopted the federal standards for qualifying exigencies. Okay, we're making our way through this pretty well. Hopefully you're starting to be a little more comfortable with this topic. Hopefully you're not ready to fall asleep on me. That wasn't the purpose of this picture of this bed, but I do want you to be able to sleep a little easier regarding this subject going forward. But we're well on schedule here, and we'll get to some questions here shortly after we just tackle a couple more general topics. So the first of those is, we talked about the qualifying circumstances. Now, once somebody is on leave, what do they get? Well, they get money because it is a paid family leave program. They also are eligible to have their health insurance continued while they're out on leave, like the FMLA. They have the right then to be reinstated either to their own position or a comparable position with comparable pay and benefits at the end of the leave. They have the right to retain any accrued benefits when they come back. They don't have the right to accrue new benefits, so they don't have to receive new seniority or get credit toward their vacation time, etc., for time that they were out and not working, but whatever they had earned up to the point in time that they went out on leave, they're entitled to retain. And then they are protected from discrimination and retaliation. So you can't treat someone adversely based on the fact that they used or requested paid family leave. This picture here is just of a couple of people. I mean, this idea here is that the employees have it pretty well under this law, especially for some smaller employers. This is likely to be pretty burdensome that employees get all of these rights, because it is going to make it easier for people to take time off, for better or worse. Some of the circumstances are obviously deserving of time off, but this is, again, a burden on employers who have to allow these employees to be off for this period of time. What is this period of time? Starting in 2018, there will be a maximum of 8 weeks of paid family leave, but then that increases for the next couple of years. 2019 and 2020, you can take up to 10 weeks, and then it reaches a cap of 12 weeks in 2021, obviously designed to match the FMLA leave available nationally. So the other interesting note here is there are specific provisions that cap the total combined use of paid family leave and New York State disability leave at 26 weeks. those short-term disability benefits are capped at 26 weeks right now. So within a 52-week period, and that is a backward-looking 52-week period from the date that someone is using leave, you can only have a total of 26 weeks between the disability benefits and the paid family leave, and only this number on the slide, given the right year of it, can be used for paid family leave. The most obvious scenario where you could run into this issue is in the case of a woman giving birth, where traditionally they've been using disability leave to take that time, some of that time off. Any leave taken before the actual birth of the child would not qualify for paid family leave, but might qualify for the short-term disability leave related to complications or medical conditions arising out of the pregnancy. Going forward from the birth, some women may be eligible to continue to take the disability leave, for up to the remaining of 26 weeks, but they would also become eligible, if they're otherwise qualified, to take paid family leave, which they may prefer to do because it pays considerably more. Briefly, before we talk about how much it pays, there is intermittent leave under the paid family leave law. Unlike the FMLA, it does have to be used in full day increments. So you don't have to let somebody take an hour here, an hour there of intermittent paid family leave. You might still have to if you're subject to the FMLA. But in those cases of employees who work at least 5 days per week on average, their entitlement, say that we're under the 12-week cap, would be for 60 total days within the 52-week period going backwards. For employees who regularly work less than 5 days per week, the number of days would be prorated. So in other words, instead of 60 days for somebody who works 5 or more days per week, somebody who works 3 days per week would only be entitled to 36 days of leave. So how much do they get paid? Well, this little chart shows the maximum number of weeks in each of these years. The other thing that's phased in over the next several years is the amount of compensation benefit they receive. It's based on the average weekly wage of the employee, but it's capped at a percentage of the New York State average weekly wage. The New York State average weekly wage is currently $1,305.92. So come January 1st of next year, the most anyone can get from paid family leave insurance benefits is $652.96 per week. That's 50%, half of the New York State average weekly wage. Anyone who makes less than that average weekly wage on the state level will get paid 50% of whatever their average weekly wage is. That phases all the way up to roughly 2/3 of their average weekly wage, capped at 2/3 of the New York State average weekly wage. Just to get into the details a little bit more, this is the definition from the regulations of average weekly wage. There's obviously a lot of words on this screen, but I've highlighted and read the important ones, and basically it's 8 weeks. So what you do is you average the employee's wage over the previous 8 weeks before the leave starts, and that is the amount of wage that you then multiply by whatever the applicable percentage is, 50 to 67, depending on the year. Now, the insurance carrier will be responsible for ultimately making that determination, since they'll be the one making the payments, but you can be assured that employees are going to want to know that when they're talking to you if you're in human resources, for example. So to simplify it, it's an 8-week look back average of their earnings. What is the wage, it includes their hourly pay or salary, any commissions, any bonuses, any tips. So it's not just if you make $600 a week salary, you automatically, use that as your average weekly wage. If you've also received some commissions or bonuses in that last 8 weeks, then your average weekly wage could be higher. And if you've worked less than you normally do in the last 8 weeks and therefore made less money, or you did or didn't have overtime, that could all affect it. So this does mean that how much someone gets in benefits if they're under the state cap could could vary depending on when they take the leave. They might make more or less than they would have if they had started their leave at a different time. If there's any severance pay or any money that the company pays towards any, health or life insurance benefits, those are the only types of things that are excluded from wages. Here's just an example chart of what it's going to look like over the next few years. If you have somebody who doesn't work that much, doesn't get paid that much, one or the other or both, and say they only make $300 per week, they're going to get the full 50 to 67% of their wages as their benefit. You can see what that looks like, ranging from $150 to $200 as we phase in. Some other examples are shown. The third row is the current state cap. So the 1305.92. If you are making exactly the state average weekly wage, then that's the benefit that you will get over those years. But that New York State average weekly wage will predictably increase somewhat each of these next several years. So that's what the next row shows. If somebody's already making over that cap in 2018, they're going to be limited to the 652.96, but they will make more than the 55, 60, 67% of 1305.92, because that New York State average weekly wage will go up somewhat. Doesn't typically go up tremendously from year to year in recent times, but it's possible. All right, mostly procedural types of things here. Next few minutes to wrap up. The notice requirements. I have a nice clean bulletin board here. I'm sure all of you in your workplaces have this much extra space to make another posting, but of course you will have to do that. This posting will be like your workers' compensation insurance posting, confirming that you have coverage, and you should receive it from your carrier, assuming you are not self-insured. If you're self-insured, then your third-party administrator, etc., will work on that, or you'll figure it out. But so that has to go up as a poster. The next thing you have to deal with is, and that has to be up by January 1st. The next thing you have to do is have some form of written guidance. Now, if you have an employee handbook or policy manual or something that's distributed electronically or in paper to employees, then you have to include information about the New York State paid family leave benefits in that. If you don't currently have something like that, then you have to provide that information in writing in some other form to all of your employees. We don't really have any samples. The latest FMLA regulations actually included a sample notice document for employers to use, but we don't have that from the Workers' Compensation Board as of yet, to my knowledge. Maybe that will come out. If not, then we're going to have to work on some language to put in either existing policies to include the paid family leave requirements, or a new standalone document if that needs to be distributed if you don't happen to have an employee handbook. I mentioned before the waiver eligibility obligation. It appears the employer has to let employees who would be eligible to waive coverage know that they have that right and give them a form. Again, the Workers' Compensation Board has specifically said they're going to provide that form, but to my knowledge, it's not available yet. Finally, there's a request for paid family leave form that will be promulgated. I actually have a draft version of the form that the state put out earlier this year for comment. I'll give you a link to that here in a few minutes when we wrap this up, so you can see that. But that form will come out, and/or insurance carriers will adopt relevant language into their own forms and provide those to you. Basically, when the employee comes forward and says, I need to take time off for these circumstances, they'll need to get that request for paid family leave form. Now, let's talk briefly about what the employee has to do. First of all, like the FMLA, the question is it foreseeable or unforeseeable circumstances that they might be eligible to take the leave for? Foreseeable, of course, would be an expected birth or placement for adoption or foster care. Obviously, in the case of birth, you should have a pretty good idea somewhat far in advance of approximately when that's going to happen. Sometimes in the case of adoption or foster care, it may come up more suddenly. But one way or the other, as soon as you find out, those things become foreseeable. Planned medical treatment, if it's planned, by definition, that means it's foreseeable. But if something happens to expedite the urgency of the situation, that may then become unforeseeable. Known military exigencies, same type of thing. So I put a lot on this slide, kind of representing how fun it might be for some of you to have to deal with some of these issues. Maybe that's you in the middle saying, really, all of this again? Either we avoided this by not having enough employees be subject to FMLA, or I finally figured that out. Now I have to learn a new set of rules. But it's somewhat similar to the FMLA if you are used to dealing with that. For foreseeable situations, the employee is supposed to give 30 days notice. And in all circumstances, up to the 30 days, either if something becomes foreseeable in less than 30 days notice, or it just wasn't foreseeable at all, they have to give notice as soon as practicable. Practicable is specifically defined in the regulations to mean as soon as possible and as soon as practical. So if you're ever wondering what practicable means, apparently it means as soon as possible and as soon as practical. And I'll let you debate among yourselves whether that really, helps anything. But for whatever it's worth, the form of the notice from the employee, they don't have to do it in writing. They don't have to use any magic words. They don't have to say, I want to take New York State paid family leave. They don't have to say, I want to take leave because of the serious health condition of one of my family members. They just need to give sufficient notice to the employer of the qualifying event, the anticipated timing of it, and the anticipated duration. In other words, my mom's having surgery next month and I'm going to need to be out for 2 weeks to help her recover, would be sufficient notice. I'm going to be having a child in August, would be sufficient notice. For intermittent leave, just to note that the employer may require notice as soon as practicable before each day of intermittent leave. Some forms of intermittent leave come up on a day-to-day basis, in which case as soon as practicable is probably not very far in advance. But to the extent that someone has regularly scheduled treatments, for example, if the schedule changes, then they should be letting the employer know. But that should be in your written policy to let them know that they need to let you know as soon as practical, so they don't just think they have the right to not show up because of their treatment without letting anybody know. Now, finally, tying back that last item on the previous slide, the request for paid family leave is going to be a form document that the employer is going to have to help the employee get once they give sufficient notice of the need for leave. But then it really becomes the employee's obligation. So I'll show that on the next slide. First, the form goes to the employee. The employee fills it out and gives it back to the employer. The employer enters the necessary company information, including confirmation of wages, dates of employment, that type of thing, gives it back to the employee. Then the employee needs to fill out the appropriate certification. In family medical leave, FMLA world, we have certification documents. Well, here the employee is going to need to provide those, but not to the employer, to the carrier, the insurance carrier. And it's going to be the insurance carrier who receives that information and then has 18 days to decide whether or not the person qualifies for paid family leave benefits. Now, obviously, in the case of unforeseeable leave, that could mean there's several weeks after the leave begins that the employer knows whether the carrier deems the employee to be eligible and qualified for leave or not. I think in the meantime, the employer doesn't have much to do other than let the person be off for work unless it's crystal clear that they didn't have the right to. In other words, they hadn't worked, enough days or weeks before they requested the leave, but were stubbornly still insisting they were entitled to it. But the problem again is that it's really the carrier's call at the end of the day, and the employer really, as far as I can tell, doesn't, under the law, have a right or expectation of even receiving the certification forms that the employee has to submit. You may or may not get access to those in talking with the carrier. But again, it's really out of the employer's hand, but certainly you're still obligated to continue the health insurance coverage and not retaliate against the person, at least up to the point in time when it's actually determined that they are not eligible for the leave. If there's a dispute over whether or not they are eligible, then no, there's not an arm wrestling match to decide that, but there is an arbitration process. Again, it's a dispute technically between the employee and the insurance carrier or a self-insured employer. So unless you're self-insured as the employer, you really aren't involved in that process, except to the extent you might be a witness or something like that. This dispute resolution arbitration process is going to take, more weeks beyond the determination by the carrier. Probably by the time it all got wrapped up, we'd be close to the end of the period of the paid family leave anyway. So you've allowed this person to be out of work, not knowing what the ultimate outcome was going to be. But an arbitrator will tell you what that ultimate outcome is going to be, albeit probably by a letter to your insurance carrier and not by a notice to you, the employer, directly, unless you happen to be self-insured. So that is just about an hour into our time, and I am done with the material I wanted to make sure everybody was aware of at this point. I do plan to have another webinar on this topic that will go more in depth in some of the complicated interaction with the FMLA and dealing with any new forms or guidance that's yet coming from the New York Workers' Compensation Board. But I am happy to take any questions right now. Here's my contact information. I have a blog on my website where I think I have about 7 posts over the last few months about this law, and they're relatively recent posts that break down the eligibility, the qualifying circumstances, the specific benefits. So those will kind of give you the idea as far as fact sheet, or if you want more reading on specific topics. So here's a question about, we have union and non-union employees. So we have an employee manual and a collective bargaining agreement, contract with the union, that is. Regarding the written guidance, they note that we can unilaterally change the employee manual, but we can't do that with the collective bargaining agreement without negotiating. Do we recommend that we change the manual, or should we send the separate guidance to all? It is a little tricky when you have a union, because there are some items that might be subject to bargaining with the union. So I think what you want to do for now is limit your guidance to what is clearly dictated by the law and regulations. I think to specifically answer the question, where you have an employee manual that you can change, the regulations basically say that you have to put it in there. But you may also have to give something to your unionized employees because you can't put it in their collective bargaining agreement. So you may have to do both based on a strict reading of the regulations. Another question. Yeah, this is a good point, and sorry I didn't fit this in somewhere earlier. Am I correct in understanding that the employer cannot mandate that an employee use accrued leave time? Whatever leave time that employee has accrued prior to leave must be preserved while they are out on paid family leave. It's complicated. I think you're basically right. It's clear that the employee has, first of all, it's clear the employee has the option to use that accrued time. If they would otherwise be entitled to, arguably if you have a sick time benefit and they're taking time off not because they're sick, which wouldn't qualify for paid family leave anyway, you might be able to deny them sick time benefits if you wanted to, depending on what your policy says. But, vacation time, for example, presumably they could use, and then if they get full pay for some period of time at their choice, then the employer has the right to reimbursement from the insurance carrier for the portion that the insurance would have paid. Similar to what most people do with their, or a lot of people do with their disability benefits now. The primary difference being that the paid family leave benefits are significantly higher, at least for employees who are relatively well compensated, or at least even comparatively well compensated. As far as mandating it, the regulations are somewhat complicated and misleading because they do say that if you could mandate it under the FMLA, then you can mandate it under paid family leave. The problem with that is that the FMLA itself does allow you to require an employee to substitute another form of paid leave for unpaid FMLA, but doesn't allow you to require an employee to use another benefit where they're already getting paid. They're already getting paid for their time off. So because the New York paid family leave is obviously and by definition a paid leave, I don't think the FMLA would allow you at the federal level to require someone to use vacation benefits, for example. So the fact that the state law says that you can do it isn't going to trump the federal law. So yeah, I think at the end of the day, barring some circumstance that I haven't anticipated, it's really all up to the employee whether they want to use accrued leave time. And then if they don't use it, clearly they have the right to use it after they come back, the same way any other employee would have been able to. Good questions. We have another question. Can an employee who qualifies for short-term disability use short-term disability and then paid family leave after the short-term disability is up? Yes and no. I think the answer to your question is no, in the sense that if they use the full 26 weeks of the short-term disability, they cannot then immediately use the paid family leave because it is a combined cap of 26 weeks looking back in the last 52-week period. If they, however, only use 10 weeks of short-term disability leave and then have paid family leave, they can use the full paid family leave immediately thereafter. But there would have to be two different qualifying circumstances because the short-term disability circumstance wouldn't qualify them for the paid family leave, other than in the complicated situation of a pregnancy where you can have some interaction, but there the note is just to remember that paid family leave cannot be taken before the birth of a child, except I should note that for foster care and adoption, the law does allow the paid family leave to be used for proceedings and circumstances leading up to the adoption or leave. So if you need to have like a family visit before the child is placed, then the law would seem to allow paid family leave to be used for that, and potentially even legal proceedings related to it. But that wouldn't be the case in the birth situation. There's not the same coverage. These are very good questions. Does anybody else have any other questions? I appreciate all of you sticking through the presentation, and happy to follow up if another question about the presentation comes up. And if you need any additional resources or some of the links or whatever didn't work for you, then let me know. You have until January 1st to comply with the notice requirements. You can start taking deductions from the employee's pay sooner if you want to, but talk to your insurance carrier and broker about whether that makes sense. And we'll talk again.